Hello, Be Yogi world. Just when you thought that you couldn't get enough of me, I'm back. My name's Cory Sterling. I'm a lawyer with Conscious Counsel, and I just wanted to address some leftover questions from the webinar that we did last week. I'm going to go hyper mode to make sure that we answer all of them. Remember, we're always here. We're an email away. You can just shoot us an email at, Cory@consciouscounsel.ca or visit our website, yogalegal.com, whatever it is that you need. Okay, are we ready? Question 1, do clients need to sign a waiver of liability for online classes, either live or recorded? On my website, I have a disclaimer, but is that enough? No, it is not enough. The waiver of liability is an example where people are signing away a legal right to bring an action against you. If you are facilitating a class, you have a duty of care to take care of them. You need a waiver of liability. So it doesn't matter if you provide the services online or pre-recorded or in a park or in your studio, wherever it is, waiver of liability is always the gold standard. How can you include all of the risks and outcomes in the liability waiver? The list would be endless. Luckily for you, it's a service that we provide, so we have all of this. We've been drafting waivers of liability for years. Remember, it doesn't have to be every small little thing. Like, for example, breaking a nail is not included in a waiver of liability, at least one that I've ever drafted. And that's also just because it doesn't have to be that super specific, but it has to be, remember, a reasonable outcome from the activities that you're doing. The issues when a waiver of liability gets challenged is when the activities are too general or the outcomes are too general. So that's the main way that you want to think. As an individual teacher, when I offer public community classes via Facebook or Zoom, how do I capture waivers from folks when I don't know who's going to be showing up? Answered in webinar. I see that in brackets. Awesome. You've got the answer to that. I'm super happy. Should disclaimers be displayed or verbally spoken every time you start a live video? I would do both. Remember, I spoke about law as storytelling, so you want to have as much support as possible. If you're unable to capture people's emails or get them to sign waivers before they participate, it never hurts at the start of the video to direct people to a link to your website that has a disclaimer or to give an oral disclaimer, but make sure that you have all the technical elements when you do that. If you do not have a website just yet but have a Facebook page, can we include the disclaimer on the Facebook page? Yes, it can. That is a good thing to do, to include Facebook, to include a disclaimer on a Facebook business page, but also let people know that you're directing them to there. Hey guys, so excited for this yoga class. Before doing it, please check out the disclaimer on my Facebook page, which clearly outlines, the risks of doing this and your responsibility. And that's much better than nothing. It's not as good as a waiver of liability, because remember, a waiver of liability is a signed agreement where someone gives up their right to sue you. And a disclaimer is more you telling people something, but it's very unilateral. It doesn't have the same binding effect. Next question. In regards to Instagram and Facebook video classes, should the disclaimer be displayed each time at the onset, or just having it on your website profile good enough? Ideally, you want to direct people to the disclaimer every single time. Hey, so excited to practice. Before practicing, please check out my disclaimer, which can be found in the link below this video, or which can be found by visiting my Facebook page. Something of the sort. What if my class gets shared with others that did not register or sign a waiver of liability? How does my liability play out? In the same thing that I've been mentioning, the gold standard is you have the information of who's participating in your activities, and you have them sign a waiver of liability. In the event you cannot do that, have the disclaimer there. If someone else is sharing your video for you, like my partner or my friend shares it with her community, do everything you can to get as much information about who's watching the video. And then especially in that case, if you don't know who the end user is, make a disclaimer at the start, let people know where they can find something written, and ideally do your best to get their email in the future to have them signing a waiver of liability moving forward. What about others who join in a Zoom class what about others who join a Zoom class along with a person who paid? Trickier, because that person off the bat, I assume that if someone's paying, you have a service agreement with that person that says that they will not unlawfully share it. In the event that they are, you would still be liable to that person, but it would be difficult for them to make a claim. But again, always just follow the same checklist steps of the first thing that you want to do is have a waiver of liability. Then you want to have a disclaimer that's posted somewhere on either your website or your Facebook or your LinkedIn. And you want to direct people to that disclaimer orally at the start of the video. When using Eventbrite, is it a good idea to put the online disclaimer within that platform? Yes, certainly. And also remember, when you're using Eventbrite, you capture people's email addresses so you can send them an email afterwards and say, hi, we're so excited to have you at Yoga in the Park. Before we allow you to participate, you must sign this waiver. I ran a yoga festival in Canada for a couple of years, and that's exactly how we did it. We got the emails, and then before we would allow people check in and register, they would have to sign things electronically beforehand. Do class participants have to sign a waiver for every class? No, so long as the activities that you're doing are the same and that you have a waiver that is properly drafted. Participants do not have to sign a waiver for every class. And when I say a waiver that's properly drafted, two things just to keep in mind is one is when we're talking about affirmation of health, making sure that they affirm that both that time they're doing the class and any future time, the responsibility is on them to affirm that they are healthy enough. And then again, so long as the activities that you facilitate are as stated in the agreement that is signed, then you're in great shape. Electronic signatures, yes, participants can use electronic signatures. Make sure you have a provision in your agreement which states that electronic signatures will be acceptable. Does having them sign a Google form count as a signed waiver? What constitutes a waiver is the legal elements that I mentioned in the webinar and how the agreement is technically structured. So you could have the content of a waiver of liability in a Google form, so long as it is signed and you have a copy of that signed document, then it would count. It's not like the waiver of liability is the content, not the medium. So it doesn't matter if it's a Google form or if it's a PDF or whatever it is. The important thing is that the information there is specific to your business and ideally drafted by a lawyer. Last question, what about evergreen online courses that students can do on their own? Is this something that should have a liability waiver or disclaimer? Yes. If you have an online course at Conscious Counsel, what we would recommend would be an online course agreement as well as privacy policy, terms of service, and online disclaimer. The reason online courses are tricky because the biggest issues we see come up with people sharing that unlawfully. So you want to have an agreement that particularly spells out what process has to happen if someone unlawfully is accessing or using that information. Also, we've had situations where clients have let people into their online community or students into their online course, and they've wanted to ask those people to leave afterwards. And they weren't able to because they didn't contractually have something. The more you can have in writing, the better. Lastly, disclaimers are really important for online courses when it comes to things like guaranteed results, refunds, what your qualifications are, any testimonials you may use from clients. All of those things fit into a professionally drafted disclaimer. So there we go. We did it. 8.5 minutes of pure information. I hope you had fun. Remember, you can visit yogalegal.com or just write me an email if you want to connect. We're here to support and sending all of our love to the Be Yogi community. Ciao, guys.